That's right!
Welcome to The Know. I'm Ashley Jenkins.
And I'm Gus Sorola.
Hey, so you know that EULA that you never read every time you buy a video game console or some other brand new gadget, the one where it tells you that you're gonna owe Sony or Nintendo your firstborn child and 77 pounds of silver if you mess with your new console in any way? Well, the Supreme Court may have just paved the way for making those arguments non-existent. You don't have to read it if it doesn't exist.
In a new ruling that has some big implications for the tech industry, the Supreme Court handed down a decision this week that gives the rights of your hardware to you after you purchase it. Whoa, what a novel concept.
Weird, right?
Rather than the manufacturer merely just giving you a license to use it.
Say, hold on, you own the shit that you buy now? That's crazy talk. So this ruling actually opens the door to all kinds of things like repairing consoles without sending them to the manufacturer, or better yet, for some consumers, legally modding them. Well, sort of. That one's a little bit trickier, but it's still a big legal step in that direction.
However, it could also pave the way, according to some experts, for changes in the ownership of all products, including digital goods like software, which would be a much bigger deal for all of those video games you own.
Right, or that you have a license to.
Right.
But before we get to all the big implications for video games and the other sectors of the tech industry, let's first get to what the Supreme Court case actually is. And surprisingly enough, it's all about the exciting world of printer ink.
Wow, people still use printers, huh? All right, the case itself is called Impression Products, Inc. versus Lexmark International, Inc. And it's had a long road in getting all the way to the Supreme Court with a ton of tech companies throwing their official support on both sides of the legal argument.
All right, so here's what it's all about. Lexmark, if you didn't know, is a printer company that sells printers. But in addition to printers, they sell printer cartridges, which, if you've owned a printer, you know can be super crazy, ridiculously pricey every time you need to refill your ink.
Traditionally, Lexmark has given their customers two ways to get new cartridges: buy a single-use cartridge that you discard when you're done, or basically do a subscription program, or as they call it, a return program, which lets you buy discounted cartridges so long as you give them back when you're done.
Now, you know the drill if you've ever bought any kind of technology. If it's a bunch of proprietary nonsense to keep you spending money with only Lexmark or your printer ink needs.
Ding. However, one company found a way to eat into their model. A West Virginia company called Impression Products started buying the discarded single-use cartridges and selling modified versions of them so they could be refilled by someone else besides Lexmark.
Lexmark didn't like that too much, as you can imagine,
Yeah.
and ended up suing them for patent and copyright infringement, and Impression Products didn't like the idea of being sued, so it kicked it up the chain of appeals courts. Their basic argument is one that many of us have said a lot of times ourselves: why shouldn't consumers be able to do what they want with products they legally own?
Because of that pretty meaningful issue, several companies have jumped in on both sides of the dispute. Some big players have filed briefs on behalf of Impression Products and being able to own your own shit, including Vizio, Dell, Intel, LG Electronics, HTC, Costco, and Western Digital.
And in Lexmark's corner, you'll find some of the industry's biggest patent holders, companies like Qualcomm, IBM, Nokia, Dolby, the ones who have a financial interest in you not doing whatever you want.
I would say Costco's the weird one in all of this. It's all tech companies and Costco.
Look, Costco sells so much stuff. They're a huge market.
No, it makes sense. I get it. Just Costco. It's like a really lame version of the airport shutdown Civil War, but it's all been kind of a big deal because so many businesses, especially in the tech space, rely on the loss leader model. A loss leader model meaning you take a hit on something you sell to make more money on it in the back end as its proprietary owner.
That's actually exactly how a lot of video game consoles work. With that business model, they hook you on a console, the manufacturer barely makes a profit, or sometimes they lose money on it in order to get more money from you in the long term through subscription services or software, the attach rate.
Yes, and preserving the loss leader model was the position of many of those opposing tech companies. They've argued to the Supreme Court that if you lessen the power of patents and give companies less control over their products after they're sold, you potentially kill off a very valuable part of the market.
Meanwhile, the other sides argued, so what? Competition's a good thing. The more of it, the better.
Yeah, so how did the Supreme Court rule? Overwhelmingly in favor of Impression Products with a vote of 7-1.
And the majority statement from the Supreme Court left very little wiggle room for their interpretation of the law, namely that once you buy something, it is yours to do with as you please.
As is common sense, I think.
You would think so, yes, but it's all those EULAs.
I hope we find out who that one dissenter is later in this article. Chief Justice John Roberts said, Lexmark exhausted its patent rights in these cartridges the moment it sold them. A patentee is free to set the price and negotiate contracts with his purchases, but may not, by virtue of his patent, control the use or disposition of the product after ownership passes to the purchaser.
So Roberts went on to say that product is no longer within the limits of the monopoly and instead becomes the private individual property of the purchaser with the rights and benefits that come along with ownership. Not licensing, ownership.
The opinion also says that anyone who makes a purchase of a product is allowed to resell it without fear of being sued for patent and copyright infringement, which that one seems pretty obvious and like it should have been the law, you know, forever ago?
Sure. Again, that last piece, kind of a big deal. Patent and copyright infringement were two of the big staples for how Sony eventually went after GeoHot following his hacking of the PS3 and the subsequent breach of PSN, saying that even though he owned the hardware, he was not actually free to do whatever he liked with the console.
To be fair, he also broke a bunch of other laws that would have gotten him in trouble anyway.
Well, there is that.
But those were the key pieces of their complaint against him.
So in addition to ruling that a product is yours to do with as you please, so congratulations, you now own your console.
Yay.
The Supreme Court also said that this ruling holds up whether or not it's purchased domestically or internationally, which potentially means lower prices on some technology here if you buy it from a third party.
That's part of why Costco jumped in, for support of impression products. Theoretically, major retailers like Costco could buy tech products like TVs or video game consoles from around the world now, then bring them to the United States and resell them to customers. Previously, patent holders were able to dispute this under broad interpretations of patent law.
All right, so that's all well and good, very interesting, but how does it matter to you watching this at home or on a toilet or a bus somewhere,
hey,
wherever you happen
to
to be? Dude, toilet watching is a big deal. Well, the Electronic Frontier Foundation, which is a big voice for consumer and digital rights, says it's not only a big win for the right to own a philosophy, but also one for the right to tinker as well.
If you're wondering, that could extend to modding hardware and products you purchase. So does this mean you're legally in the clear if you want to start hacking your console to sell pirated games? Not exactly, no.
Yeah, even if you don't have nefarious purposes in mind for console mods. The problem is that so many of these hacks are often combined with ways to circumvent firmware, and getting around the software, the firmware software is still protected by DMCA.
However, this does remove that restriction from modding consoles. It's just one less thing they can slap on a civil suit. The most important thing it does, though, is to give you more of a right to repair and open the door for local repair shops to fix your consoles for you, rather than sending them into Microsoft for 6 weeks at a time.
Yeah, unfortunately.
You can send them into anyone. We all know Microsoft because of Red Ring, but it's anyone.
Unfortunately, not going to stop them from sticking it in the EULA, though. Even though the Supreme Court has deemed it legal, a manufacturer could still try and slap you on the wrist for violating your contract with them, since signing the EULA is technically entering a contract, but it's way flimsier than violating patent and copyright law.
Fortunately, there are bills in the works from some state governments, like the Right to Repair Act, that'll go a long way toward this too.
Thanks, tractors. But more importantly, the EFF also calls this an important decision toward the same right to own philosophy for digital goods as well, because currently the rights for software are still considered to be non-transferable licenses. You may own the disc, but you only license the game that's on it.
Oh, okay. This is why you can't resell digital goods because of previous legal precedents. They're viewed as licenses rather than tangible property like anything else. However, the EFF feels that we're now a huge step closer to changing this interpretation.
So, really boring court case actually stands to have really big consequences for stuff you care about. Imagine that. What do you guys think of the Supreme Court ruling in favor of consumers actually owning their stuff? Let us know in the comments.
And for future updates from the law offices of the Know, remember to like this video and subscribe to the Know if you're new around here. We're not actually lawyers.
I'm a lawyer.
Oh, can you have a law office and not be a lawyer? Like, could you have a law office that's just, I don't know.
What if you just obey what if you just obey the law in that office?
Then it's a legal office.
I mean, all you have to do is hop over a bar